Hi, everybody. It's Elektra Yao, artist, visa lawyer, and entertainment lawyer. I know I haven't been going live as much as I should, and I've actually been getting quite a few requests, so I'm actually back by popular demand. But I got a request in particular in the last couple of days that I think it's worth it for everybody to just hear another overview of the O-1 process and the artist visa process, especially because I think everyone's getting really nervous because it's an election year, because maybe their OPTs are close to expiring and things like that. We are very excited here at Yao Law Group because we have a lot of really exciting changes going on that I can't wait to discuss with you guys later on in the future. But today, let's just have a conversation about the O-1 process, and I want to try to deconstruct it and break it down for you so that you understand the different elements or the different requirements for this type of case. So the first thing that you need to understand conceptually about the O-1 is that it's a work visa, which means that you can't volunteer your time or your work. You absolutely need to be able to demonstrate to the government that you're going to be working. So there's two ways you can start to conceptualize and think about work. You can either file for an employer-based petition or an employer petitioner, where you have one job and you're tied to that one employer for the validity period of the O-1. Now, remember, the maximum validity period for the O-1 is 3 years. So you would be tied to that employer for 3 years unless you file an amendment or you file an agent-based petition, meaning you would file with an agent petitioner. And with that agent petitioner, you will be allowed to work on behalf of multiple employers. So that agent petitioner, that is like the vehicle, the conduit that allows you to work with different employers. Now, working on behalf of different employers is one of the most exciting aspects of the O-1. That's what makes it very different from the J-1, the H-1B, the E-2, all these other different types of visa options. That's why the O-1 is very, very special and highly coveted. Now, working on behalf of multiple employers really depends on what you want to do in your career. So this is a very strategic decision that you and your attorney would make. Like I said, it really depends on your career goals, what you want to do, what you want to accomplish, what impact you want to make in the field. But for the sake of today, let's just talk about filing with an agent petitioner and having the ability to work on behalf of multiple employers and what that means exactly. So when you file with the agent petitioner, remember, you need to prove your agent. So you need to prove that ability to work on behalf of multiple employers. So you're going to have the background information of the agent to prove that the agent is either a U.S. citizen or a green card holder or a U.S.-based company. And you're going to have the agent agreement, which is an agreement between you, the client or the beneficiary, and the agent, which basically states that the agent is petitioning on your behalf. Once you have that settled, now you move on to the contracts. So the contracts, the law says you need at least 2 future work contracts, but that's just the minimum. You can file with as many as 15, and I've filed with at least 15 contracts for some clients who are high profile and who have lots of projects, or even 3. So the legal minimum is 2, but you can file with many, many more. Now, the types of work that you want to do, whether you're going to be a teaching artist or just an artist or a performer or just a teaching artist, again, these are strategic decisions that depend on what your future goals are and what your future employment looks like. So you've got your agent agreement, you've got your future contracts. Now you need to move on to the forms. So the forms are Form I-129. So that's the form for all non-immigrant visa petitions or visa applications. And you have your Form G-28 if you're represented by counsel, and your Form I-907. So the Form I-907 is for premium processing. Now, remember, everybody, premium processing is changing. So as of now, premium processing is 15 calendar days. So 15 regular days, Monday through Sunday. But it will be changing to 15 business days, meaning it will be Monday through Friday. So 15 business days will equal to roughly 3 weeks. So 21 regular days. So you've got your agent agreement, you've got your future jobs, you've got your immigration forms, Form I-129, Form G-28, and Form I-907 if you're filing premium processing. And now let's talk about the different evidentiary requirements. So part of the O-1 petition or the O-1 application is the advisory opinion. So let's take an example. Let's say you are a performer. So a performer is an actor, somebody who's acting on stage or acting in film and TV, and you're going to need a letter from a labor union. So this letter from a labor union is called a letter of no objection. So you need this letter. It's actually a requirement. You need this letter to submit your O-1 petition. So that's one part of the evidentiary requirements. Number two, it's press or publication. So press is anything in the media, online media, trade magazines, newspapers, online publications that directly describes you or projects that you've been in. So let's say for the sake of conversation, you performed in Evita and Broadway World has written an article about Evita and name drops you and mentions you. This is considered to be press. But to satisfy this criterion, you can actually also satisfy it with publications. So let's say you are a graphic designer and you are specialized in typography and you decide to publish an article on medium.com about the different types of typographical techniques one can utilize. That also satisfies the national and or international recognition criteria. So advisory opinion from a labor union, press/publications. Now let's talk about portfolio. So your portfolio is basically, the way I like to see it and conceptualize it, is basically the overarching story which discusses your specific achievements. So again, this is a very strategic decision, and the way that story is crafted is strategic, and it depends on you and the attorney that you choose to work with. I like to focus on the beginning, the middle, of the end. I don't like to give them everything. I like to just give them what I believe is the strongest evidence or the strongest part of my client's portfolio. Because remember, we need to prove extraordinary ability, distinction in the field, and different achievements that he or she has garnered in her field. So very recently, we just got an approval for someone who just had one job in her field. So very, what I would call entry-level case, but I was able to very creatively argue her special and unique professional profile and get her an approval in 13 days without premium processing and without an RFE. So again, remember, how you craft the story or how that story is crafted about the client or the beneficiary is very, very important. It's really not about, sometimes I like to say it's not the more the merrier, or sometimes I say it's the more the scarier. It's not really about inundating them with paper. It's really about choosing and selecting specific achievements that speaks to the expertise of the individual. So you don't need to have 20 jobs to be able to qualify for the O-1. You just basically, in my opinion, need to be able to really craft a strong story. And you guys are artists, you know what I'm talking about. You guys tell stories all the time, whether it's through dance and voice and singing and graphic design. I'm able to tell your story with the law. So again, the portfolio is this ensemble of curated documents by me, curated documents that basically proves everything that you have done in your career. So we're really looking at the context. So I like to see production pictures, behind the scenes pictures, contracts, thank you notes, emails, receipts, invoices, pay stubs, rehearsal schedules, performance schedules. I like to see all of that because that really helps me tell your story. So again, every attorney is different. There are different ways to tell a story, but I like context. I like to have really quality documents that really make you shine. So we talked about the advisory opinion. So let me just recap from the beginning. We talked about the immigration forms. We talked about the agent agreement. We talked about the future jobs. We talked about the advisory opinion. We talked about the press/publication. So you can either publish an article or you can have press about you. We're talking about your portfolio. So now let's talk about high salary. So a lot of the times clients will say, oh, well, I'm not making a lot of money. I can't qualify. So the high salary element is part of the criteria, right? So you need at least 3 criteria to secure the O-1. There's a maximum of 6. So there's 6 criteria. You need a minimum of 3 to qualify. I typically argue 4, but it really depends on the profession. For my art directors, for my creative directors, I mean, we can argue high salary because those are professions where clients tend to make lots of money. So maybe for a performer, let's say your salary is, one of our recent successful performers was making $14,000 a year. So some attorneys put varies in how much you're going to make. I don't really like to do that because I really like to give USCIS the information that they're looking for. And that number of how much you're making should actually be memorialized in your contracts. So you don't need a high salary to qualify for the O-1. It's not like the H-1B where you need a prevailing wage. And I think that's where the confusion happens, because we have so much information about the H-1B that sometimes we try to take that information from the H-1B and apply it to the O-1, where sometimes the information is transversal, but not all the time. And especially in this case, you don't need a high salary. So high salary is not a requirement, but if you're making high salary, you can certainly argue it. So let's talk about the significant recognition criterion. So the significant recognition criterion is really interesting and fun criterion because you can argue a couple of different things. But one of the most classic ways of arguing significant recognition is through the use of testimonial letters. So a lot of the times I get asked, do you need a minimum or a maximum amount of testimonial letters? The law is silent about this. So it depends on the professional style of the attorney that you're working with. Sometimes for really high profile clients, we don't need as many, but other times I feel like the story of the client is so compelling that I'll include 14 testimonial letters. The legal requirements for these testimonial letters is the background of the signer. So they need to be experts in the field. So let's say you are a makeup artist and you decide to get a testimonial letter from a talent manager. Well, I think I could probably make a successful argument that a talent manager understands the expertise of a makeup artist, but you want to make it easy for the officer to really understand your profession. So you might want to get a letter of recommendation from an actual makeup artist. So an actual makeup artist who understands the different shading and contouring and colors and complementary styles and face shapes and all of that stuff, to be able to speak as an expert about your expertise and about the field in general. So there's no minimum, there's no maximum. You can include, sometimes I've included 5, sometimes I've included 14. It really depends on the professional profile of the client, of the beneficiary. Another way that you can argue significant recognition is through awards. So if you've won an award in your field, there's definitely room to argue for this criterion, that you've been recognized by an organization. Another creative way that I view significant recognition is for my clients that have really strong social media presences. Sometimes attorneys don't like to use that, but if I have a client who has really, really focused on her social media presence, and I do have these clients, then we definitely include it, because sometimes they're even verified. And I'm not talking about famous clients. I'm talking about people who have invested in their social media and end up going through the verification process. And we include that because that's being significantly recognized by a large social media platform. So we've talked about press/publications. We've talked about high salary. We've talked about significant recognition through awards or through experts in the field. And we've talked about your portfolio. So that's an overview of the different evidentiary requirements of the enumerated criteria that you can prove your extraordinary ability in the field or your distinction in the field. So one thing to recognize about O-1s is that O-1s are very, very paper heavy. I just filed a case today that wasn't so paper heavy because client has a very, very strong profile. But you're working with a lot of paper. You're working with a lot of documentation. So if you are on your OPT right now, or you are thinking about applying for the O-1, or you're thinking about, doing being very strategic with your immigration journey and maybe applying for the H-1B and applying for the O-1, or applying for, multiple visa types simultaneously, what you really want to focus on with your O-1 is you really want to focus on your portfolio. You really want to focus on that aspect of storytelling. I really invite you to think conceptually about this, to think that, hey, there's going to be somebody deciding my future who knows nothing about graphic design, who knows nothing about the performing arts, who knows nothing about dance. Really, they don't have the professional and artistic profile that you guys have. So you should really, really work hard to save all of those little details that can potentially play a role in telling your story. So whether it's emails or pay stubs or invoices or contracts or badges or thank you notes, save all of that, because then you give more evidence that the attorney can play around with in terms of telling your story. But play around, I mean, in the sense, evaluate what is the best for your petition. So just to give a recap of this O-1 is you really want to identify whether you're going to file with an agent versus an employer. If you file with an agent, one thing that's really, really important and really special about the O-1 is that you can always add additional performances and engagements if they fall within the purview of how your petition has been classified. So if you have been classified as a performer / teaching artist, then you most likely, you have to seek legal advice on this, but you most likely could probably add additional teaching roles and additional performance roles. So story time. I just had a consult with somebody who filed with an incorrect professional title. And when I say incorrect, it's not really what she wanted to do, but she was stuck with that title and stuck with that employer because she didn't really explain to the attorney what she wanted to do, what her goals were. And basically, I guess she sought us out because she wanted confirmation from me that she could engage in this future work. And the answer was, based on my analysis of her petition, that she really couldn't do that. And if she did, it would be a violation of her current status. So figure out if you want to file with an agent versus an employer. If you file with an agent, you need at least legally 2 work contracts. Once you've gotten those work contracts, you want to fill out the Form I-129, Form G-28, Form I-907. After that, you want to get your advisory opinion. So whatever union governs your profession, you're going to want to get that letter of no objection. You want to start to work on your portfolio. Remember, your portfolio is your ensemble of documents curated by your attorney that really tells your story. After your portfolio, you want to start to think about significant recognition. So who's going to be signing your letters of recommendation? And that, in a nutshell, is a very, very brief overview of the O-1. So I hope that this was helpful for those of you who contacted me via email and who wanted an overview of the O-1. And I hope that this will motivate you to start to think more conceptually about the O-1, more conceptually in terms of really seeing the O-1 as an opportunity to kind of map out your future role, your future job, what you want to do, what your goals are. You want to be here for 1 year, you want to be here for 10 years, whatever it is. Start to think big. I always tell my clients, think big, think long-term, think about what you want to do. So I gave you lots of information that I think will be a good starting point to start to at least think critically about the O-1. Again, it's a lot of information, but if you don't want to watch the video, you can certainly go on my website. I might put a couple of links in the comments so that you guys can go and directly look at my articles that outline the different aspects or requirements of the O-1. So I hope that this was helpful. I will probably be back later this week to talk about these really exciting new changes that are going on with our law firm. I'm super excited to talk to you guys about what we're doing, how we're thinking about our clients differently, how we want to offer different services to clients so that clients can start to understand really their career differently. And I think that these different changes that are happening with Yao Law Group are going to be really beneficial to the artist and creative community. So please stay tuned for our really exciting news this week or next week, depending on how quickly things roll. But I'm excited for you guys. It's like I said earlier, it's you still have a couple months to be big, to do great things. If you're on your OPT and you don't know what to do, send me an email. Happy to consult with you and provide you proper guidance. Remember, guys, October 2nd, all the filing fees are going up. So if you've got stuff pending, you might want to get that out quick if you're working with another attorney or if you're working pro se on your own. Otherwise, remember, the filing fees will no longer be $460 after Friday. They will go up to $705. So hopefully this was helpful. This will put you on the right track, give you a good foundation to start thinking about your O-1 critically. And if anyone has any other requests, please send me an email. If I'm not live, it's not because I don't want to be live. It's because I am working and serving my clients, my artists, my creatives. So I will be back hopefully later this week or early next week to continue this conversation with you guys and to motivate you to think big about your O-1 and think big about your careers. So I will see you later this week. Any other questions, please send me guys an email. If you don't know what my email address is, Google me. How many Elektra Yaos do you guys know in real life? Bye, everybody. Speak soon.